Welcome to Case by Case. This is a podcast brought to you by Luke and Calum Chain from ZFZ. How are you today, Calum?
Very good. Luke, how are you?
Good. We got one from across the pond over in New York to discuss today.
An arbitration award from New York, and the immediate point of difference that I noted, being an English lawyer, most of my work being based in England, is that this is not an anonymized arbitration award. This is very much a public arbitration award, published, I believe, as is, signed off by the tribunal with parties named, and all of the comment and discussion and awards laid out, as I believe as it would be, in the partial final award. So what's going on there?
I know. We actually know who's involved. That's the way they do it over in the Society of Maritime Arbitrators of New York. They actually publish their award just like a court judgment. And I did wonder, does that mean that we should identify the arbitrators if we, might go on in our podcast to, opine on a different view than has been expressed here or not? Or do we not? Do we just let our curious listeners go and dig out the SMA award and find out who gave the decision themselves?
I mean, I think you're more likely to know them being more in that market than I am, but I agree with them here anyway. So
do I. So we've kind of given the game away. I totally agree with the decision. I think it's right. And we're talking about demurrage claims and time bars. I don't think it's the first time we've touched on this in the podcast, and probably not going to be the last time. But interestingly, as is often the case, this case gives us the opportunity to look at some other principles that we know well on contract construction and how to approach clauses. A few takeaways, probably one we can skip through at a beat. And yeah, I think it's a good one. Thanks for joining in today. We're pleased you're one of our listeners. We hope you stay with us and that you're enjoying these episodes. If you do like them, please do subscribe to us on Spotify, YouTube, Google or Apple, wherever you listen to your podcasts. It's greatly appreciated. And thank you for your patronage. So let's get into it. Hey, Calum, I'll give a quick citation and go through the parties' names. And then how about we identify the facts?
Yeah, sounds good.
Alrighty, so this is, as I said, an SMA award in the arbitration between Stolt Tankers as the disponent owner of the MT MONAX as claimant, and as respondent we have Stryker Fuels, who were the voyage charterer under an ASBA form with the charter party dated June 29, 2021. This is SMA number 3449, and the decision was handed down relatively recently on August the 4th, 2022. So we have a dispute here between owners and charterers under a charter party, and it's all about when notice of the demurrage claim was given. Is it out of time for the time bar provision in this contract? Importantly, and I'm sure this is one of the points Calum will mention in the fact summary, we're talking about a 2-trip direct continuation voyage charter party. Super important for the outcome. So it's a 2-trip, 2 voyages under this one charter party agreement.
Exactly. So we've got, as you say, Luke, we've got the owners, Stolt Tankers, and the charterers, Stryker Fuels. And they've agreed this 2 continuing voyage charter party. The first is from Ontario to New York, and then there's presumably a ballast leg, and the second is from Ontario to Antwerp. In each case carrying product. And after the first voyage, it seems as though there was some problem with the product on board. It was a residual fuel oil, so there was some issue with the fuel oil. It seemed to be very hard to discharge. It needed a lot of tank cleaning. I think there was a lot of kind of sediment and all these kind of issues that you may get from a cargo which is not quite on spec, and caused significant damages up to around about $1 million. It seems like there's some loss of time. There's also some part of the claim which is for tank cleaning, and because of all that, owners had a significant claim they wanted to bring against charterers, and they did bring a claim against charterers, and charterers said, "No, sorry, you're too late. That claim is time barred." The reason the charterers said it was time barred was under clause 20. The first point of interest I had around this clause 20 is that it's broad. So we often see these types of time bars, particularly for things like demurrage. But this is broader than just demurrage. This clause 20 says, charterers shall be discharged and released from all liability in respect of any claim/invoice owner may have sent to the charterer under this charter party, unless a claim/invoice in writing, accompanied by all supporting documents to substantiate each and every constituent part of the claim, shall be received by charterer within 60 days of completion of discharge of the cargo covered by this charter party. I think we'll come back to that wording a number of times in this podcast because it is really a construction dispute. But the owners, the charterer, said, "Sorry, you're too late. This cargo was discharged, and it was discharged a long time ago, more than 60 days ago, and the precise day that charterers said was the 29th of August. They said time bar expires on 29th of August. That's 60 days after discharge, and the notification of the claim comes through on September the 13th. So 15 odd days after the charterers contended that the claim was time barred, and owners said no, and they advanced two grounds really to say no. The first of which was that not all the cargo was discharged at the kind of quote unquote end of discharge, and they basically said, well, because we had to scrape up all the residue and we had to go through this product of cleaning away all of the solids that had formed, that was part of the cargo, and that actually hadn't been discharged until later. And at that later date, we would have been within time. But the second argument that they ran, which ultimately was the one that the tribunal took more interest in, was that the clause was drafted to have a time bar that was effective 60 days after completion of the cargo, quote unquote, covered by this charter party. And the owners said, well, it's a 2-voyage charter party, and the issues happened on the first voyage, but the cargo covered by this charter party is the entire cargo for voyage 1 and voyage 2, and there's no reason that the time bar should be triggered solely in relation to voyage 1, when the cargo covered by this charter party is clearly voyage 1 and voyage 2.
Yeah, exactly. So just to make sure we're crystal clear here on the timing of what happened. So you had voyage 1, voyage 2, notice of claim given shortly after voyage 2 completed. So if you ran the 60 days from, let's say, most of the cargo came off the vessel on voyage 1, notice was given outside the 60 days. If, however, the cargo covered by this charter party in clause 20 in the time bar clause refers to all the cargo, so cargo in voyage 1 and voyage 2, then the notice of claim was within time because it was given shortly after the second voyage. And on that first point, when I first read that as one of the key arguments, I was a bit, I'm not sure about that point. I'm interested in what you think of that one. I know it wasn't the decisive factor, but I thought, you can argue there's still some residue floating around on that ship somewhere out there, and that somehow that time hasn't started to run. I don't know. Look, there's no doubt a degree in there, and if you're talking about 10% of the cargo still remains on board, then okay. But if you're talking about tank cleaning and residue and some sludge, I'm not so sure. And I didn't find that a particularly compelling argument. So I thought as I was reading it through, I thought, charterers, they have something in here. But the second point, when you look at the clause, you can actually see genuinely that it's unclear as to what this means. And it wasn't a factor in this, but it would be interesting to know from a subjective perspective whether the owners actually thought on a reading of this clause whether they were in good time by issuing their notice shortly after the second voyage, because completion of discharge of the cargo covered by this charter party. There's nothing in covered by this charter party that distinguishes between voyage 1 and voyage 2. And if anything, I think a plain reading of covered by this charter party means all of the cargo in the charter party. Now, the panel looked at it from a couple of perspectives. One, an equitable perspective, which we'll come on to. I wasn't sure that was the most important, but they looked at it primarily from, is this clause clear, or is there ambiguity in the clause? And if there is ambiguity in the clause, then that should be read against the drafter. And the drafter here was the charterer. Yeah,
exactly. And one of the interesting things I thought in the decision from the tribunal was that they actually said a fair reading of clause 20 leads the panel to the finding that it is not clear and unambiguous. So they found there is some ambiguity there, and as soon as that happens, as the charterer really that the claim's gone, because as the owner that the time bar defence is not going to work for the charterer, because as soon as it's not clear and unambiguous, it's then going to be read against the charterer. And in this case, as we've discussed, there are kind of two ways of looking at that wording: the cargo covered by this charter party, and the less favourable one to the charterer who's trying to rely on the time bar is going to be the one that the tribunal adopts. The odd thing for me, Luke, is I don't know if they needed that word at all. I mean, if you remove that wording, covered by this charter party, then I think probably charter's in a better place. I mean, what other cargo could they be talking about?
Yeah, I agree. I think it's unfortunate drafting. I really do. And as I read it, there are definitely two potential meanings here, and I think it's probably meant to be after discharge of each parcel of cargo. But that's okay. I see the two alternative constructions here. But when I read it on a plain reading, covered by this charter party, I actually think the more natural interpretation of that is that it's an attempt to cover all of the cargo under the charter party. I actually think it's, if I had to just prefer one or the others without using contra proferentum, I would say it's more likely actually that it's all the cargo under the charter party. And that's what covered by, which is an odd phrase to use, covered by this charter party is intended to do. So I'm not sure the owner actually needed contra proferentum, but it's there. And given the ambiguity and two rival meanings, the one that goes against the drafter is going to prevail. So, but what's important here, I think, also that the tribunal identified was that it was quite possible for the charterer to clarify and to differentiate between the two separate voyage cargoes. And unfortunately, they did not do so in this case. So it's one of those classic situations of where you have a standard form in-house set of terms which the charterer no doubt uses invariably on their shipments. But then something happens on the commercial side to say, okay, this is going to be a 2-trip deal, and a thought is not given then to how the recap or the actual fixture itself is going to then interact with some of the standard language that's found in the rest of the contract. And we see this time and time again. not just in this context, in all sorts of contexts. And it's something that I know we say often, but going and reflecting on some of this key language can be critical. There was also this point, what did you make of the discussion about, the equities, and that, there's a tendency in the authorities when dealing with time bars that, they shouldn't be, so a legitimate claim should not be dismissed on kind of equitable grounds. And that then put against some of the clear cases previously in under SMA rules that were referred to here of tribunals upholding clear and precise time bar provisions. I just thought that those two principles kind of rub up against each other a little bit here.
I agree. I actually don't think there's anything unequitable about relying on a negotiated time bar clause. And if it was, if it's Mr. Bloggs who's agreed a contract with a big company and he's ticked the box saying, I agree to the terms and conditions, and like the rest of the population hasn't read the terms and conditions, and then there's a time bar that stops him having a otherwise legitimate claim against this big company, contracting purely on their own terms, etc., etc. Maybe there's room for an equitable argument, but these are two parties who are contracting on negotiated terms. They're both, they're both in the market, and they can negotiate whether or not they want a 60-day period from completion of discharge. And I don't think there's anything particularly equitable about taking it away from a party that's agreed to it. Looking at it the other way, is it equitable to say that charterers are not entitled to rely on a contractual provision that they've negotiated, and presumably the other party has in some way priced into the contract, whether it's with, maybe in the negotiation they accepted the time bar but got something else in that they wanted, or maybe I doubt it'd be the case for a time bar, but maybe there's a pricing differential, maybe there's some quid pro quo that gets charterers this time bar. I don't see how equity would really be invoked to release owners from it.
I entirely agree with you, and that was really the point I was driving at, because it's this line that kind of jumped out at me. Notwithstanding the ambiguous wording of Clause 20, we find that under equitable principles, the matter should proceed to a final resolution in further proceedings and should not be dismissed pursuant to an ambiguous and unilaterally drafted claims time bar clause. Fundamental fairness and good commercial practice demand otherwise. I get why the tribunal got to that point, and I see where they're coming from, but this wasn't necessary to decide the case. So we're not talking about anything that was decisive in this matter. But I'm not sure I agree with that point, is what I'm saying. Like you, I think even if it is drafted by one of the parties, and that is a factor when it comes to a contra preferentum analysis, fine, I get that. That makes some sense to me. But the idea that it's been unilaterally drafted and that then sways into equity in a situation where you've got two commercially sophisticated parties that either had or could have had lawyers easily advising them on these contracts, I'm not so sure. And so I kind of think that point there was a bit of a reach, but nonetheless.
But I think the key word in that point is ambiguous. So we find the equitable principles of the matter should proceed to a final resolution in further proceeding and should not be dismissed pursuant to an ambiguous and unilaterally drafted claims time bar clause. I think if that sentence did not have the word ambiguous, then I would disagree quite strongly, particularly from an English law perspective with it, because I would say, well, if there is a clear, unambiguous time bar clause, even if unilateral, if it's agreed to between two commercial parties, then I don't see why equity would come in and disrupt that. But the fact that it is ambiguous, I think, opens the door to for the tribunal to add this kind of equitable part of the decision.
I agree. And look, ambiguous appears twice in that sentence. I think what was triggering me was the notwithstanding the ambiguous wording of Clause 20. And then it went on to say this point. And that was what I was like, but I take your point, perhaps semantics. Okay. Anything else coming out of this this award that you wanted to touch on?
One more general point that I've seen with a couple of, well, I say time bars, but I'm not sure they actually are time bars. In this clause, it's very clear the effect of failing to notify the claim within 60 days. The clause actually leads with that. Charterers shall be discharged and released from all liability in respect of any claim/invoice owner may have sent to charterer on this charter party, unless it's within the time period. What I've seen a couple of times, and I haven't seen cases turn on this, but I've seen clauses that simply say there is a deadline of 60 days to bring a claim for demurrage. But it doesn't have the second part where it says charterers must bring owners must bring their demurrage claim within 60 days with all supporting documents. But it doesn't have the second bit that then says failing to do so will mean that the claim is deemed waived, discharged, barred, etc. And it's always interested me, was a kind of point of interest for me as to whether or not that would actually be a time bar. If a owner breaches that kind of provision and simply sends the claim late, then would the effect of that be that the claim is barred, or would charterers have a hypothetical damages claim for any damages suffered by the late sending of the notice?
My initial reaction to that would be the latter. I think. Can't say I've thought it through, but I think you need, given the effect of time bar provisions, the draconian nature of them, that they need to be expressed clearly. The effect of them needs to be set out. There's this principle is referred to in this award and others that parties should be able to pursue legitimate claims, and if there's going to be a clause that gets rid of an otherwise legitimate claim, it needs to do so clearly, and it needs to be clearly agreed. So, without that language, without the discharging language, without the release language, and the effect of the clause being sufficiently clear, I think it's more a breach scenario. I had another couple of points I wanted to make, and I'm not entirely sure whether this was clear or not, but it seemed to me, like if I'm looking at this from the charterer's perspective, and where I might have been disappointed with the result, is I couldn't see whether the point argued about supporting documentation was properly dealt with, because wasn't there a point made that the notice of claim didn't have all supporting documentation with it when it was sent? Now, I don't know whether it was then sent within 60 days of the second voyage. Maybe it was, so it's a moot point, but I didn't see that in there. And that, to me, I think could still be a good argument, right? It's pretty clear on what has to happen, and that all supporting documentation to substantiate each and every constituent part of the claim has been received within 60 days. And I didn't see that being dealt with at all, actually, in the decision.
Yeah, I agree with you. And my assumption is that supporting documentation therefore was provided within the time, but it's not dealt with. It doesn't say that it was. And it was a separate argument raised by the charterers. It's right at the end of the sort of charterers' contentions part of the award, where it's kind of carved out separately, saying charterer also contends that owner did not only fail to submit a claim within the time bar period, but also did not make reasonable efforts to provide any supporting documentation within the time bar period. So it may have been that it lived and died on what the time bar period was, but I agree with you. I didn't see anything dealing with that in the decision.
The last point that I had was on, this is kind of asides, I suppose, and I don't think the argument goes anywhere. But did you focus on or give some thought to the second sentence of clause 20A? So you read out before, the time bar provision, and we focused on within 60 days of completion of discharge of the cargo covered by this charter party. And then you have this second sentence as a part of the same subclause. It says, all claims shall become due for payment after completion of the voyage. That, to me, I don't think it's enough to eradicate the ambiguity in the preceding 6 words or so, cargo covered by this charter party. But when you take them together, that second sentence there talks about after completion of the voyage and claims becoming due after completion of the voyage. It does seem to have some truncation between the 2 voyages on at least, claims becoming due for payment, and whether that can then be linked with when notice should be given on demurrage claims.
That's a good point.
I don't think it was argued from what I could see.
Yeah, it's certainly not mentioned in the awards, but
of course, in the award it's not mentioned as being argued. But I don't know whether it was argued or not.
But it is a good point, because you go back to your principles of construction and reading the clause reading the words in light of the rest of the agreement, and certainly in light of the rest of the clause. They're talking about claims. The claim has to be received within 60 days of completion of the discharge of the cargo covered by this charter party, and then it says all claims shall become due for payment after completion of the voyage. I think there's something in that. It's a sensible argument to run. I still think that the way the wind was blowing with this particular panel, they weren't going to get home on those kind of arguments either, because if the panel was going as far as looking into the equities of the situation and finding on the basis of the equities that there was a good equitable reason to have the claim heard, then they're probably pretty far through the analysis to get taken back by this. But if the panel had been on the fence, then that kind of wording could have helped make it clear that the time bar is supposed to refer to each voyage rather than the entire charter.
That was if I was looking at this afresh, and I was trying to see what I could find in there for the charterer. Those would have been the 2 key arguments that I'd be focusing in on, because I think you're always going to be up against it on the overall equities of the situation, even though I think that shouldn't be a deciding factor in and of itself at all. But once you get into an ambiguity discussion and you're then preferring different constructions, once it's going to be difficult for the drafter of the clause to survive. But I would have been focusing on that to say, well, actually, you don't need to look beyond the clause to understand or to resolve the ambiguity. You can actually resolve it by looking at the clause itself. I don't think that would have prevailed, I've got to say, but that's kind of where I would have been going. But the supporting documents point is one I continue to have a lingering question about what does it mean by all supporting documents in these provisions. And I know there have been some English cases on it, but there's going to be something that really tests this one of these days. What does that mean? And is it documents in your possession? Is it documents that you can get? What does substantiate mean? And for me, if full supporting documents weren't given within 60 days of the second voyage, that seems to be a real key argument in this, that I just couldn't see whether it was that it got much life. Anyway, probably longer than we anticipated, Calum, as typical, as we do. Can't help ourselves, we get into them. Always enjoyable. Thanks for jumping on, and thank you everyone for listening in. If you've made it this far, you've heard us go over a New York SMA award on demurrage time bar contractual provisions. So hope it was useful. Any questions, drop us a line anytime. We're happy to answer any questions you've got on this case, any other case, or indeed if you've got a suggestion, if you'd like us to look at a particular jurisdiction or a particular case that you've heard about, want to know what we think about it, we're always happy to share our views, as you know. Until next time, take care.
Cheers, Luke. Cheers, everybody. Bye.